conference participants. My name is Jorge Luis Fabra-Zamora. I am currently a postdoctoral fellow at the University of Toronto Faculty of Law. I am really happy of sharing with you today some views about the idea of social groups. Let me begin with two comments. First of all, I'm going to present a different, my paper is slightly different from the abstract I submitted in the light of the audience. My original paper was a bit more focused on the legal theory side, but during my research, I have noticed that there are important insights on social ontology that I'm trying to work, so I have focused on that, and I believe that's helpful for you. And on the other hand, I'm not going to use my my camera because the file will get too big. So from now on, I'm going only to use my voice. I hope that is not too boring to you, but thank you so much for staying with me. First of all, let me begin by providing some context of my project. I am not a social ontologist, I am a legal philosopher, and I have been working for the last couple of years in providing a unified theory of state law and these flourishing forms of non-state legal phenomena like international, transnational, and global law. And the key idea of this work is that law exists within political communities, special arrangements that we call political communities. So modern state is one, but also historical arrangements such as the Greek polis, the Roman civitas, but also we have seen new forms of political communities in the form of lex mercatoria, transnational commercial law, or lex sportiva, transnational sport law, or human rights and international law of trade, and so on and so on. While doing this work, I have noticed that legal theories have developed a theories of political communities, and in doing so, they have developed a theory of groups, because political communities are a subtype of groups. So political communities are large-scale groups that claim autonomy and use coercions, but in doing so, legal theories have developed a theory of groups which is closely connected to the theory of norms, and groups becomes the basic entities of the social normative world. And this is the motivating intuition. I believe there is an important theory of group that can be rescued from the work of mainstream legal theories, and that theory can help illuminate the idea of groups and resolve major problems in social ontology, and that is the project. This is not a finished project, but I want to start working in this intuition, and the motivating thought is that an improved account of norms, such as the one provided by jurisprudence, leads to an improved account of the whole social world. So the problem of groups is one of the central problems of social ontology. So the intuition is that there are some distinctive collective of agents that have a special theoretical and practical relevance, and we need to account them. And these collectives are called groups, and these groups can act in the social and normative world in many different kinds. So a central question of social ontology is that do these social groups exist, or are just a fiction, or are just a metaphorical language? But more importantly, if they exist, what are they? And there is a flourishing literature and numerous views on this. So I want to provide a contribution. Here I want to adumbrate, I want to suggest a provisional kind of groups inspiring the work of major legal theories. Main sources are Hart, Finis, Honore, Russ, and the view, as suggested in the previous slide, is that in developing a theory of norms, they have developed a theory of groups. And the central ideas of this novel approach is that groups, we're going to provide a theory of normative groups, namely groups created by norms, which are distinct from featured groups or classes, and they cannot be unified. So social groups and practice-based norms are co-constitutive notions. A theory of norms entails a theory of groups. This theory of norms provides a distinction between two kinds of groups: on structure or sets, and on structure on groups. Importantly, group can be nested into another group. There's a central insight that is helpful to understand the nature of groups, because they can be created by norms, and some norms can create groups within groups, and groups can be constituted by shared action, but also by concentrated social pressure. This is an insight that is present in some social ontologies, but I want to stress and further clarify here. So this account has some distinctive feature. On the one hand, it is in line with the conception of groups developed by Raymond Tumela and Thomason in a recent paper. Also, it compares favorably some recent accounts. In particular, Ritchie and Gilbert is going to be the main foils for purposes of this paper. And this conception helps to solve, or better, to dissolve some major metaphysical problems of groups and set the stage for political moral questions about that connect social ontology with political philosophy. I'm going to present my normativist account of groups in 3 steps. By a normativist account, I mean an account that is centered in norms and based on the intuition that norms are the central building blocks of the social normative world. So the building blocks of these normativist accounts are the notions of norm, practice-based norms, normative groups, normative orders, and order constitutive and order constitutive rules, and I'm going to provide a summary account of all of them. So for norms, I'm going to use any standard that guide behavior, so including principles, rules of thumb, recommendations, recipes, and so on. So norms can be divided in 2 kinds, non-practice-based and practice-based norms. Practice-based norms are those normative phenomena which are created by complex of human action, namely behavior and attitudes of a certain group of people. So 2 important clarifications is that unlike Ross and other accounts, I'm going to distinguish between the complex of human action, the practice, and the complex of norms fixed by that practice. That's a central insight of jurisprudence. And I'm also going to distinguish between the norms created by the practice and the values that they entail. So I have a comprehensive account of practices that is developed in full in the paper. But when a practice-based norm contrasts with non-practice-based norms, which are norms that haven't been taken up by a community, and they are not used to guide behavior, and a community is not used to censor or evaluate the behavior of certain agents with that. So Plato's proposals for ideal state is a non-practice-based norms that haven't been yet enacted, or plans of norms or norms that are extinct, that are no longer practiced, are not examples of practice-based norms. They are non-practice-based in my account. What is a critical point highlighted by most jurisprudence is that a theory of norm presupposes a theory of a group. This point is suggested by Hart when he talks about the rules of that. The rules, his favorite example is the rules that about wearing hats in the church. That norm presupposes a group of churchgoers. The rules about sports presuppose that there are players, and that rules are actualized in practice presupposes that there is a group of agents that are using these norms in practice. And this point is put more bluntly by Tony Honore, that says that instead of asking what is a norm, we can also ask what is a group, and he has a comprehensive account of groups as a basic building block of legal theory. So I'm going to call groups as these pluralities of people created by norms, and groups and norms and practice-based norms are co-constitutive notion. For something to be for a group to exist, you need norms, but norms at the same time are the central elements that define groups. In these accounts, we don't need common values, common goals, shared activities, or proximity. Groups are defined by shared commitments to norms. And one key element of my proposal is that I distinguish between groups and communities, but I'm not going to go here. The 2 final elements are normative orders and order constituted rules. So I follow that one of the central insights of contemporary legal theory is the collectivist principles. We need to understand norms as a collective, and these norms often work in terms of normative orders, which are unified complex of interrelated norms that regulates a domain of actions. And these norms have some features that they bear normative relationships and display indicators of unity, and I have tried to read the theories of contemporary legal theories as theories of this unity, like the rule of recognition or Kelsen's group norms are ways of showing how norms are unified somehow, and they are a manifold so they are one complex and not merely a manifold of norms. One important feature is that the explanation of this complex take priority over the explanation of individual aspects, and this is a central insight of contemporary jurisprudence, and I try to explain which is the consequence of that. And one of the most important ones is the explanation of constitutive rules. It is a recurrent puzzle that I'm working in a different paper of social ontology. Is about what are constitutive rules and how they are different from other ones. And my central insight is that we are better understanding constitutive rules in terms of order constitutive rules, and this is a specific goal that has been so elusive to contemporary social ontologies, and I'm trying to articulate why this jurisprudential based conception compares favorably to Searle's based conception on several grounds, including the ability to explain rights, which is the most common objection raised by Russ and Warnock, among others. It is a central insight of contemporary jurisprudence the distinction between two kinds of normative orders that I'm going to call set and systems. Sets give rise to what I call unstructured groups, and system gives rise to structured groups. And the key idea is that it's based on the central normative activities of every group. These activities are the identification, modification, and application and enforcement of those groups. If a group has determined standards about these central activities, is called a set. If a group doesn't have determinate and precise standards, if it has them, it's called a system. Legal theories have developed these determinate and precise standards and have given them names such as rule of recognition, rules of change, and rule of adjudication. This underlying theory has a rather simple intuition. Is that normative systems are groups and communities that provide guidance to their participants about which are their norms, how they are created and applied by whom. One simple way to introduce this intuition is by thinking in informal or institutionalized games. So the games that we play with our friends and families without referees are examples of normative sets without codified rules or referees that apply the norms. However, when you introduce a codification of norms, that's a rule of recognition, and you introduce a referee, you introduce the germ of a normative system, and it brings to the fore new questions. So by introducing the problem of a referee, an official, you introduce the problem of authority. Why this person have the ability to apply the norms on behalf of the group, and it becomes institutionalized, the structure of authority, and doctrinal inquiry concerns with the codification and how this codification applies. So this distinction between unstructured and structured groups is central for doctrinal questions about the application of norms, political questions about authority and legitimacy, and I'm going to try to show later how it helps to explain many basic insights about the social normative world. And third, I'm going to introduce as the third part two components. On the one hand, like two forms of articulation of groups, of creation of groups created by legal theories, and the nested nature of groups. So a common view by social ontologists is that groups are generated by we intentions, or by shared commitments. I'm going to call groups that are created like that associations, but this is not the complete story. Hart have developed an really interesting idea of how systems come to place that has important consequences for the theory of groups. Tuomela has developed some similar, but I believe the jurisprudential one has developed the same insight at a greater development. So in this view, groups can be articulated in two ways. One is that everybody, all members, agree to create a group. So that's the collective view. So groups are created by shared commitments. And that's one way, and that explains a particular form of operation of groups, in particular sets. However, jurisprudence have developed a new account of groups that is based on the idea of systems, on the idea that there is a minority of powerful agents that Tuomela calls operative agents and legal theories call officials that are able to make other people to bind other people as group members through the exercise of social pressure. Hart's accounts of the minimal conditions of the social system presented in chapter 6 of the concept of law is the best account of that. So the idea is that a kleptocratic state is a group, but a kleptocratic state is not a group created by a shared commitment, as some people like Ritchie or Gilbert will suggest. If a kleptocratic state is created by some people monopolizing pressure and forcing other people to participate, and these are real groups, and these are groups that can act. So a kleptocratic state have a collective will, a collective intention, but there are differences in the kind of responsibility that members have. So one important issue is that jurisprudence doesn't think this is commendable. They think this is possible, but it is not how things should be run. The second element is the nested nature of groups that can be accounted. So if groups are created by norms, norms can give rise to groups that are not based by the we or shared intentions of people. So for instance, a state, which I'm going to call a higher level group, can create a lower level group, can create a university by state issuing norms creating a university. A university is a new type of group, or it doesn't mean that it's hierarchically bound to the state or anything like that, but it's a group that can be it can be created by norms. And regulated by norms, and it's a group that, for instance, at the beginning doesn't have members. So these modes of nested natures could go bottom up, like groups creating getting together and creating higher layer groups, or be to top down by higher level groups, like state imposing lower level groups. So these three elements developed in the previous section provide the germ of a new theory of groups. So first of all, this is not a unified account like the one attempted by Ritchie. I am not trying to explain both normative and feature groups. It's a theory only of normative groups, and feature groups can be entered in this picture once they have normative relevance. That's an idea that I developed further in my paper. This is a new candidate view that is opposed to familiar views such as group as set, segregation, and structure. It is important insight that it explains why all groups are not based on we intention or shared commitments, and it explains the problem of parenthood. How can groups be created and be part of other groups, or be created by other groups? It explains the view about organized and disorganized groups, for instance, that is confused, for instance, in Ritchie's famous paper of 2013. It provides accounts, the germ of new accounts of collective intentionality, group duties, individual responsibility, depending how this happens in unstructured groups of sets or structured groups of systems. And for the purpose of legal theory, it helps to frame several important political questions like membership, recognition, representation, inclusion and exclusion, legitimacy, and the possibility of self-legislation, and many others. But more importantly, for the purpose of social ontology, it helps to resolve and dissolve some classical problems. And I believe some problems that have been called the metaphysics of groups are based from translating metaphysical problems of material objects to groups. But if we conceive groups as normative creations, we are going to see that these problems might be apparent. So let us provide one example. Is the problem of the identity of change of members that has been worked a lot by Urquizo. And the problem is like, how can Supreme Court be a group when all members are changed? And there are many different ways to resolve and address this puzzle. But if the group is a normative creation, we can explain simply how it can persist in time. Rather simply, how can it persist in time while members change group? So more importantly, a Supreme Court is not a group created by we intentions of all the members. It's a group created by a higher layer group, which is the state that establishes an institution, and we can see how this puzzle is resolved. We can explain also how groups can have the same members, which is called the coincidence problems, because they are created by different norms. Also, the problem of location is like, where is that has been framed in different ways, like where is the Red Cross or where is Canada? Norms typically define, provide a solution. It's like when you ask where is a group located, the question is, where can I talk to this group, or where can I have in communication with this group? And groups provide, and norms of group constitution provide resolution on those questions, and also provide resolutions to issues of temporality. Groups exist with norms, and they are extinct when those norms do not exist, and groups they are contingent because they do not exist in all possible worlds. They are entirely norm creations. So in sum, what I have tried to develop here is a novel theory of groups that complements some stand accounts, that challenges some widespread views about groups, and that helps frame and answer some metaphysical questions about groups that I believe that can be resolved by seeing things, seeing groups not as material objects, but as entirely normative constructs, and also help frames political and moral questions. But I believe the most important contribution of this paper is that helps to bring the gap between social, legal, and political philosophy. As I see them, there are different ways of seeing the norms, of studying norms, and norms are these basic building blocks of the social reality, and an improved account of norms lead to an improved account of groups and other social practices. So thank you so much for your attention. I look forward to discussion. I hope this is interest for you. This is a work in progress, and I will be strongly benefit from your comments. This is my email, and if you want to continue the conversation, and some works that I have been doing recently that might be of interest of some of you. Thank you so much.